Hi, everybody. This is Arkady Frekhtman, a New York City personal injury trial attorney, and welcome to Last Week Tonight Live, where we answer your questions live. So, welcome, everybody. Thank you for watching. And let us know what questions you have. You could drop them in the chat. I'm monitoring the chat live. I'm happy to answer. But I'll start with some of the questions in our channel. I'll go back to some of the questions that we get on our channel. So here's a question that we got just 55 minutes ago from a Juan Ramirez. And he says, how does the age of the plaintiff affect a personal injury case? PTSD, for example. What is the plaintiff, or I think he's trying to say, what if the plaintiff is young and suffered a bad trauma due to negligence? Okay. Yeah. So if, obviously the age of the plaintiff affects the case in the sense that if you're younger, then you have longer to live in the future. So then you should be able to, if you have a serious injury, you should be able to recover more because the law has to compensate you for all of those years. So for example, I represented a young, I think she was 18 years old, and according to the life expectancy table, she had 60 years to live into the future, over 60 years. So we asked for a greater amount. We said, look, because of it's a serious, permanent, life-changing injury, and this particular young girl, she was 18, she was in college, she has over 60 years according to the life expectancy tables in the pattern jury instructions. So therefore, the amount that you should allow for in your verdict should be higher. So that's basically how it works. Now with PTSD, that's post-traumatic stress disorder. I did a video about that, how PTSD is similar to a brain injury. So if it's a really significant injury like that, where it affects your brain, it affects the way that you interact with the world, basically, then if the plaintiff is young, it should be a very big case. It could be a very serious case. And if the trauma was due to negligence, then that's exactly what you have to prove. Because one of the things that you have to prove as a plaintiff is, number one, that the defendants were negligent. And that just basically means that they didn't use reasonable care, but also that their negligence was a substantial factor in causing your injury, right? So you need to prove both. You need to prove causation and you need to prove negligence. So that sounds like a good case. I'd have to get more details, but from what you wrote so far, that sounds like a pretty strong case. And then Mike Cook says, I hope the defense is never ready and is demolished during the trial. I can imagine your client's disappointment who is waiting for civil justice. Oh, and he was responding to our video from last week. I think he's talking about the fact that one of our trials got adjourned. Yeah, I was upset about that too, but you never know. I mean, the problem with the courts is that, this particular case, I was upset because you show up there and, we made a motion in November of 2022 for what's known as a preference, because the case is just on the calendar. But in this particular county, this is in the Bronx, New York, there are a lot of cases, right? And you're all on the calendar and you're all waiting and nothing's ever happening. So we're waiting just like everybody else. And we're actually suing a municipality. So it's even longer. It's like a different calendar, even slower. So we make a motion in November of 2022, and the motion is unopposed, right? And then the motion gets granted in, I believe it was January of this year, right? And right at the beginning of the year, the court says, you have this trial date, May 15th. So we're great. And we have 5 months to prepare for it, almost half a year to prepare for it. And we're corresponding with the defense lawyer. We're sending them our notices, our pretrial subpoenas, emails, photographs, everything. They know the case is going to trial. They even call. They said, what's your demand? Let's try to settle. We're going to call the money person. We have so many conversations. Then all of a sudden, May 15th comes around. We show up to court. And instead of sending the lawyer that's going to try the case, the lawyer we've been talking to all this time, they send some other lawyer. And the lawyer's well, I don't even know this is on for trial. I thought this was just on for a conference. And the judge is first berating him, what are you talking about? You have this court order for half a year. And then for whatever reason, just does an about face and says, okay, I'm going to give you a little bit more time. But it wasn't adjourned too long. It's going to be probably this summer, I think in July. So a few more weeks. So I'm just going to use the time to prepare even more, get the case even stronger, you could always be better, right? So I'll just use it and get even better. What can you do? That's just something that happens. Unfortunately, like I really think when they give you a date, they really, because if they respect the lawyer's time and everyone's time and the court's own credibility, right? Because if they're telling you, hey, this is your trial date, and then you show up and you've prepared and you've paid your doctors, and I mean, this particular trial, we have many witnesses, we have more than 10 witnesses, they should at least respect that and have you go forward, or if you have some kind of excuse why you can't. But there was not even really any legitimate excuse. So I don't know. But what are you going to do? And then he asks, is it true that defense lawyers who only defend have to handle too many cases at the same time and therefore are at a disadvantage? I mean, I don't know. It just depends. Like all the defense lawyers are different. Some of them are insurance defense lawyers where they do have a lot of cases, and what they also do is not only do they have a lot of cases, but they kind of work like 9 to 5. They never really work like weekends or work late or prepare the cases. So they kind of just go through the motions because they get paid a salary. So, so of course they're going to be weaker than a lawyer who is preparing, and really has their heart into it, really is passionate. But whether they have too many cases or not, I don't know. And then, I think a lot of them are also, they're not like, they're defending it on different grounds. Some of them may try to defend it on some technical ground, but not really defend it in the right way or in the way that a jury might see it, but rather on some technicality. So, but they're all different. Some of them are a little bit like, I don't know what I like to call maybe like tone deaf. They don't really like listen. They don't really like understand kind of like the temperature in the room. They don't really feel it. They just kind of like read their boring medical records or something. I don't know, but they're all different. So some of them are very good. It just depends who you get. So we'll see. We'll see what happens. Okay, here's some live questions. Here's a question. Let me see here. Let me see. Live chat. Here's a question. I see a question. Had my femur broken by a third party, surgery, 5 days in the hospital, 23 days in rehab, and then a third surgery to take all the hardware out, and the knee revision done a year after. Other knee hurting from walking with a gait. It happened in upstate New York. Yeah, I'm sorry to hear that. That sounds like a strong case. I mean, as long as it's a good liability, meaning the other party was at fault. That's a very serious injury. A surgery like that, known as open reduction internal fixation, plus the removal of hardware, should be at least a few $100,000, like many hundreds of thousands. Like we had a case similar to that. I think we settled it for about 1.25 million, from what I remember, 1.3 million. But that was in New York City. So if upstate could be a little bit less, depending on the juries. But it should still be significant. That's a serious, serious case. I'm sorry to hear that. And then someone else says that they were involved in a slip and fall, a horrific slip and fall in a Burger King in Queens with arthroscopic surgery to repair a torn medial meniscus and a non-displaced tibial plateau fracture, plus 2 herniated discs, and treating with physical therapy and pain management with 3 injections. Went to a neurosurgeon that said they had a traumatic lumbar spine injury and recommended a multi-level fusion. Liability is established. Knee didn't respond well to surgery, and now there's a recommendation for a total knee replacement. Yeah, I mean, that's also like a very, very serious case. I mean, the hardest thing with slip and fall cases, in my opinion, is establishing liability. So if you've already established liability, or you feel like you have, your experts, you have your photographs of the defective condition, and you can win on liability. Sometimes plaintiffs, even in New York, what they do is they file a motion for summary judgment, because there's a new case law a few years ago where in some circumstances you can actually obtain summary judgment as a plaintiff. And then you have a judgment as a matter of law that you win. So that's always very beneficial. But But in other circumstances, if you don't win on summary judgment, as long as you have all the evidence, like the photographs, the defective condition, it's unsafe. That's the most important thing with slip and fall cases. But these injuries are, yeah, massive. I mean, knee surgery, total knee replacement. It's hard for me to say exactly. In Queens, Queens is a pretty good venue. It just depends on the jury that you pick because Queens is so it's like a melting pot. You have so many different communities. So I think the lawyer should spend a lot of time picking a jury and getting the best jury possible. But that could be a big case in Queens. That could be worth many millions because if you need a total knee replacement, I've seen a lot of cases go for millions just with a total knee. And plus, you said a possible fusion. A fusion is very, very serious. We talked about it in some of the past lives that we did, how serious a fusion is. And it's just a very, very serious injury. It basically, you lose your spine and you lose your discs, and your discs are all hinge joints where you're moving, you're bending. That's how people move. And if it's all fused together, now you've lost that mobility. You're stuck. Plus, all the nerves are running in the spinal canal and running out to the arms and to the legs, and those nerves being impinged just causes pain. So it's constant pain. So those are serious, serious injuries. If it's proven the right way and established the right way, that could be many, many millions of dollars, as long as the policy is there, which it should be. If it's a Burger King, there should be enough of a policy. So yeah, so that sounds like a good case. Okay, let me see what other questions we have. I don't see any other live questions, so I'll go to the comments. Here's a question. When both parties are scheduled to appear for jury selection, can the trial begin on the same day? Well, yeah, because jury selection is the trial. So like once you start, known as voir dire, picking a jury, once you start picking a jury, that's the actual trial because you're already starting the trial. So usually, it depends on the county. In Brooklyn, what they do a lot of the times is you'll pick a jury, and it might take a day, it might take 2 or even 3. I had one case, I think before the pandemic, it took like 2 weeks to pick a jury. Just took a long time. So it could take a varying amount of time, but usually it's like a few days. And once you've picked the jury, then you might have to wait a few days for them to assign you a judge because they have to see what judge is available. Or sometimes they'll send you to a judge. The judge will, start with you, and then the judge will say, well, you know what, I can't do this case because this case is a 2-week trial, but I have something in a week, something else that I just can't adjourn. So it all depends on like scheduling and things like that. So sometimes. But usually you just wait like a day or two, then you get assigned a judge. In other places, like in the Bronx, where I'm supposed to do this trial, but I got adjourned, what they said was they were going to assign the judge the day before jury selection. So we already have the judge. So it just depends on the county. They all have their own local rules. Okay. And then someone here says, can you do a video on trip and falls with multiple injuries? Yeah, absolutely. We've done a lot of videos on trip and falls. I think like the important thing with trip and falls is just to remember, number one, that you have to establish liability like we just talked about. That's the main thing, liability, that it was not reasonably safe, that it was, they call it ordinary care, but they really mean just reasonable care, right? Or what a reasonably prudent person would do in the same circumstance. So depending what it is, if it's like let's say a sidewalk and there's a misleveling and someone tripped over it, well, you wouldn't leave a misleveling in the sidewalk. That is unsafe. So things like that. And then the person says that they have bruised palms, a sprained wrist, chipped teeth, torn labrum. Yeah, that's very serious. Torn bicep. That's very serious. And they were told to run to a door up a ramp before they closed, and they tripped over a broken piece of wood while running up the ramp. That sounds like maybe some kind of a work injury where they said, hey, run up the ramp, and then there was a defective condition. So it could be a case, could absolutely be a case, as long as it's a third party, not just your employer, because the employer is workers' comp, but then when you sue a third party, that's the personal injury. So yeah, that sounds like a strong case. And here's a question from a Robin Shepherd. I was hit with a grocery cart at Costco while I was working. I just got hired 2 months before I was bullied every day by three girls, and one of the girls that I was working under, she was my manager. There was a camera present, and there was a young man that hit me with a grocery cart. I just got through finishing with one member, and I walked right behind the cashier that was working there for 27 years. And she has an L4, L5 injury, it says. Yeah, I mean, that sounds like it could be a workers' comp because if there was some kind of an assault and it happened at work and you got injured, you got hit from behind while working, oh, with the grocery cart, maybe it was like some kind of accident. But it sounds like, yeah, it sounds like you couldn't really sue anyone else unless a third party was responsible. You can't really sue your employer in most states. In New York, definitely you can't. But I'd be happy to maybe recommend a workers' comp lawyer for you. I do know some workers' comp lawyers that I work with here in New York. If it's in a different state, I may be able to help find one. Okay, let's see what other questions we have. Rahman says, does your firm work with interns, maybe remotely? Oh, yeah, we've had some interns in the past, but not really remotely. But I guess now, yeah, you have to be open to that, right? Now, a lot of people are wanting to work remotely. Yeah, I would be open to that. Maybe working with somebody who's either in law school or interested in learning law. We could give them some different projects. This summer might be a little tough because we have this trial coming up. So it might get a little bit busy, but maybe they can help us a little bit. Like there's a lot of things that interns can help with. I know interns sometimes help prepare, like for example, the slides. If you're doing like an opening statement and you want to show slides, like different pictures, or they'll make like a timeline, a nice timeline if they know how to use like PowerPoint or one of those softwares. They can make a timeline or they can make slides, different pictures. I sometimes just do those on my own. Sometimes I don't do them. Depends on the judge. Sometimes you can't do them, but I find that helpful. Like I kind of tend to learn in a visual way, so I think like pictures sometimes help. Or some lawyers use that, because you don't really want to go up there. Say when you're opening or you're doing a trial, you don't want to go up there with too many notes. Then you're like reading from the notes. I don't know if you guys watched that in the Gwyneth Paltrow trial. The lawyer representing the guy who was suing Gwyneth Paltrow, he went up there and he's like reading all these notes. It's not very persuasive. So it's good to know the case. So you go up there and just start talking to them, look them in the eye, but you need some kind of, roadmap. Some people use little cards and you look at the cards once in a while. But I think these slides are great, right? Because even if they're just simple pictures, like, boom, that's what I want to cover. That's what I want to cover. And it kind of helps you. Even if you can't even show the slides to the jury, you could have them on a little iPad or something. And then just for yourself, it's a good mnemonic, to know where you're going, like a roadmap. But yeah, I'd be open to working with some interns, absolutely. And then Siggy says, good evening. Everyone hit the like button to keep the channel visible in the algorithm. Oh yeah, thank you so much. Yeah, absolutely. We're here for you guys. So our goal is helping serious injury victims and families. So please like and subscribe to our channel. Let us know what questions you have. If you want us to do a video on a specific topic, let us know what topic you'd want to do. And I could do a video. I know this week I did one about pre-existing injuries because that's a very common topic. A lot of people, come into a case or they get hurt, but they already have something, right? Because it's very rare that a person is a perfect, specimen of health without anything, right? Usually people have some sort of whatever you want to call it, whether they're a little bit weak or a little bit vulnerable, or they have something that happened to them in their life before. And then what do we say? Do we say that these people who have something from before in their life, are they worth less? Or if someone is older, right? If someone is, let's say, 70 or 80, and then they get hurt, do we say that the door to the courthouse is closed to you? You can't come to the courthouse because you're older? No, right? We don't say that. Or could it be that these people who are a little bit more delicate, a little bit more vulnerable, a little bit more susceptible to an injury, maybe their injuries are worth even more? I know that some lawyers say, they have less to give, right? Because they've already have, let's say, a condition, whether it's like a herniated disc or a prior fracture, they have less to give. So this particular injury has affected them in a much worse way. So now they have less to give, right? And maybe this particular car crash or this particular trip and fall is like the straw that broke the camel's back. It's almost like the thing that pushed them over the edge. Whereas if they were healthier, if they were really strong and they didn't have anything before, maybe they would deal and cope with this in a better way. But because this happened, this is what pushed them over the edge. And now they're just have this lifelong forever injury that they can't recover from. So that's that's an interesting topic, the way you frame the pre-existing condition. And in New York, the pattern jury instruction allows you to recover for what's known as aggravation and exacerbation of a pre-existing condition. So it basically means that to the extent that that condition was made worse, you could recover for that. You can't, recover again for the condition you already had before, which makes sense, right? If you had, let's say, a herniated disc at L4, L5, you can't get into a car crash and say, I want to get recovered from it because you already had that before the car crash. But to the extent it was made worse, maybe before you had that lower back herniation and it was like, physical therapy is all you needed. But now, after the crash, you need injections, you need a surgery, so then you recover for all that to the extent that it was made worse. And it's a pretty good law. It just depends on how you frame it. A lot of things are like framing and the way that you present it, because some lawyers, they're afraid of pre-existing conditions, or they don't take those cases, or they say like, I don't want that case because it's just an aggravation case, right? So it's the way you look at it. They think it's just an aggravation case, right? They've already had this, it's not worth very much. So they're going into the trial with that kind of mindset. Just like another lawyer this week in one of the listservs, he was asking a question. He has a trial coming up, but he was asking a question about a medical malpractice case where he was talking about a risk of the procedure. So somebody had a procedure, and it's a known risk that this particular surgery can cause this injury, like a perforation, let's say, right? When the doctor's doing this particular surgery, they can perforate or cut something, and then you have this complication. So he was worried about that because he says that medically, it's a risk of the procedure. So then that's going to be their defense. So how would you handle that, right? Would you go in there and just argue your case and not say anything about that? And then the defendant will get up there and say, look, medically, in this medical textbook, it's known to be a risk of the procedure. So we did nothing wrong. This was a known risk for 50 years that if you do this, this could happen, right? And he would lose the case. So what I suggested to him, and I've read this in other books from excellent trial lawyers, the way to do it is to actually front it yourself, right? So as the trial lawyer, as the plaintiff's lawyer, you have to say, look, this is a known risk medically. And so because you already know as the surgeon that this is a medical risk that all surgeons have known for 50 years, don't you have to be that much more careful? Because this is likely to happen, that when you do this particular surgery on the duodenum in the stomach, that you could perforate the small intestine or whatever it was, I forget now what it was, but it's known that this is something that's going to happen, right? So you flip it on them and you frame it that way. And now it's like, wait a minute, of course, if you know it's likely to happen, you have to be that much more careful. And then, of course, you have to have the specific, negligence that the doctor committed. The specific, you have your own medical expert to testify and to say that this doctor deviated from the standard of care by X, Y, and Z. So, and then putting that all together, you have a much stronger case. So, yeah, absolutely. Okay, let's see what other questions we have here. Here's a question from 2 days ago. What if someone has a trial date, more like jury selection, and also has a conference for settlement right before? Why are those events taking place like that? Okay, so that's a good question. I think the reason they do that is because, look, they're going to be committing a lot of resources, right? You're going to have to commit a lot of resources to start the jury selection and the trial and pay all your doctors and spend your time. And the trial could take 2 weeks or more. The court's going to have to commit a lot of resources, right? They're going to have to assign a judge, court officers. They're going to have to hear your case. And then, of course, the jury, you're going to need a jury of, in New York, it's 8 people. In some other states, it's 12 people. And when you pick a jury, you might be talking to 50 people or more. So all of these resources are going to be committed, right? So before they start the trial, they want to have one last chance to try to settle it. To say, look, what is your final, demand? What is your final offer? Maybe we could do a meeting of the minds. Let's get rid of this case. Let's settle it. And if they can, great. Then you avoid all that, right? And if you can't, then go to trial. So it's like a last-ditch effort to try to resolve the case. So it makes sense, like logically, why they would do that. And they do that often in New York. In fact, when they call out cases in the jury coordinating part, known as JCP, a lot of the times the lawyer that answers either for the plaintiff or for the defendant will say, okay, I'm here, but a conference. And then they'll put it down for a conference, a settlement conference, to try to resolve the case, try to have that meeting of the minds. So it's something that makes sense, I think, in my opinion, right? Because why go through all that, right? Have a whole trial. Wait a minute, we could have just settled this case. So it just depends on the case. Yeah, so let us know if you have any other questions. I'm going to see if I have anything else from the comments. If not, we could wrap up a little early today, and then maybe next week I could do a few more topic videos. And let us know, like, if you have any other topics you want us to cover, whether it's like truck accidents, construction accidents, trip and falls, ceiling collapses, a specific type of injury. I know some people had questions about brain injury. When I did the spinal cord injury, I did a spinal fusion or spinal injury video a few weeks ago, and I recall somebody was asking a more specific question about a specific part of the spine. So I'm going to have to see if I can research that and maybe do a quick video about that. So yeah, let me see. Oh, here's a question. I was hit by a semi-truck, but not even my lawyer wanted to tell at least a certain amount. And for the record, the truck driver was at fault. So I think what he's saying is, like, his lawyer didn't want to tell him what the case may be worth. And a lot of lawyers are afraid to say what a case may be worth just because, they don't want to get it wrong, or they don't have all the information. So for example, say you get into a truck accident and you say, hey, what's my case worth? Well, I could say, like, usually other cases with truck accidents with this type of injury have settled for X, Y, or Z, but it's hard to know what your case is going to be worth exactly. And then people could use that against you later, right? They might get mad at the lawyer, say, hey, you told me it was going to be worth $1 million, but now you're saying settle it for $300,000. What's going on, right? So that's why a lot of lawyers are afraid to tell you what a case may be worth. But what I try to do is I try to tell you based on my experience, just looking at other cases from New York, as well as sometimes from some other states. Sometimes I do videos about that where I talk about a case from somewhere else, but then you have to give the particulars of the case. That's the only way you could really find anything out, is if you know the particulars about the case, the specifics. It's hard to answer what a case may be worth just by just a sentence or two. It's very hard. It's almost, it's like closing your eyes and throwing a dart. You might get it right, but you might not. You can't really guess like that. And then Tattoo D2 says, I wish I could chat to you directly about my case. Yeah, absolutely. Yeah, feel free. Like we give out our number where you could text me. I'll drop it here. And then maybe we could set up a time to chat. Also, in the description to a lot of the videos, especially all the recent videos, there should be a little link. It's called a formaloo. It's like a form, but it's really simple. All you have to do is put in your name, your like the facts of what happened, and your injury information. Or if you don't have an injury that's diagnosed by a doctor yet, then you would put in like your symptoms. And that's really all you need. And then I would give a little bit of information that I could maybe text you back, schedule a call, and we could talk about the case, and maybe I could help you out, or I could recommend somebody if it's in a different state for a second opinion. I've been doing that. Sometimes people call me and they say, hey, I have this lawyer or I have this new case and I need some guidance, and I'll recommend an attorney for them, and then they can get a consultation. Sometimes, I can't really control what the other attorneys do. Sometimes the attorneys take the case and help people. Like there was one case where somebody won $2 million from an attorney that I recommended. Other times, unfortunately, the lawyers will say, you know what, I can't take this case, and I feel bad, but I can't tell the lawyer in another state like in California or Iowa or wherever, like, hey, you got to take this case. I don't have that kind of power, so you have to understand it. But I'll do my best to help if I can. Okay, let's see what other questions we have. See if there's any good questions here, either from live or from the comments from before, from the chat that I haven't answered yet. So here's a question. I need you to take a case. You take cases in Ohio. Oh, see, this is another state. Okay. Yeah, actually, I do. I have some cases in Ohio with some local lawyers that I'm working on. Yeah, some strong cases. I'm a victim of a failed back surgery. I'm preparing to have a spinal reconstruction. After a fusion in 2015, I had a spinal fusion at L5S1. 3 years later, I had a repair of equipment and a repair of another herniated disc. And now all the equipment had to be taken out and I need help. Yeah, I mean, I'm sorry to hear that. I don't know if you could still sue if it's 2015 because there's a statute of limitations. I don't know what it is in Ohio. In New York, it's 2 years and 6 months, so 2.5 years from the date of the medical mistake, from the date of the malpractice. Now, if there's continuous treatment by the same doctor who performed the surgery who you think was at fault, it may get extended. So, but I can happy to connect you with somebody in Ohio. And actually, this is the link. I dropped the link here. I could drop the link in here too in this chat, but I see that I dropped the link for them for that particular. It's the Formaloo link, and then they fill out a form to give me a little bit more information, and then I can perhaps get on a call with them, schedule a call, and chat about the case. Okay. See if we have any other questions here. Yeah, like Robin says, I sure need to get some advice from your law firm. Yeah, sure. Just like text us or fill out the form. I think the form might even be better because it gives me a little bit more information. If somebody just texts me and they say, hi, okay, but then, I can't always get on the phone with everybody because I have other work. I have this trial. I have a lot of other depositions and motions and, busy law practice. But if you fill out the form, it kind of gives me a lot of guidance as to, how I can help, if I can help, and then I could just refer it to my intake team. We have an intake team of about 7 people, so they could always speak with you, or you could speak with me, or you make an appointment. So it's a lot better. Okay. And then Wen says, my landlord told me to fix my broken shower head by myself. After I gave him a doctor's note, I was injured on his property from a ceiling collapse. Can I charge him with punitive damages? Well, I don't know if you can get punitive damages. Punitive damages are hard to get usually. It depends on where, and it depends on the circumstances of all the conduct. But you definitely sounds like you have a case. I mean, if you were injured, if there was a ceiling collapse and you were injured, that's a good case. I mean, pretty much anywhere. So you could just have a regular personal injury case. You don't need punitive damages. Punitive damages are like additional damages meant to punish the defendant. So, for example, if I have a trucking company, right, and then I know that, say, a truck driver is driving more hours than they are allowed to drive by federal law, and they're super tired. But I say, you know what, I don't care. Go out there anyway. Or, I hire someone and I see, hey, they have a prior criminal record or they do drugs. And I say, I don't care. Go out there and drive anyway, even though I know you're on drugs. And they're likely to hurt someone. Now that could be punitive because then they'll issue damages against the company meant to punish me for being so reckless and so crazy, But in that case, if it's just a ceiling collapse, it's unlikely to be punitive, but it could be just a regular case, just a regular personal injury case. Okay. And then Wi-Fi Man says, do you know anyone in Massachusetts? Yeah, I mean, I do know lawyers in Massachusetts. Just feel free to text me or fill out the form. I don't like to say like who a lawyer, I wouldn't give you like one lawyer for all cases. It depends on the type of case. It says, I was driving an Uber with a delivery in the car and I got hit by no fault of my own. I suffered a post-concussion syndrome. Okay, yeah. So that could be, I could give you, like, depending on what city in Massachusetts, I can maybe give you some guidance and help you find someone that could help you with that. Yeah, that sounds like it could be a case. In terms of worth, I mean, I couldn't really tell you in Massachusetts just based on that, but I'd have to look at the medical records, all of the damages. Just saying post-concussive syndrome, I mean, that's definitely something, but I couldn't really guesstimate on worth just from like a YouTube comment. I don't think any really lawyer that could do that. You know, just that's kind of like I was saying before, closing your eyes and throwing a dart. You know, you never know. Not very specific. And then Thomas says, I have a third party case and it's going on 4.5 years, almost 5 years. I had a meniscus and ACL repair and I need surgery on a decompression of my L4, L5, and I have a dropped foot. It's a third party construction case. Any idea how much it's worth? I mean, I would definitely ask your lawyer what he thinks it's worth, what they think it's worth. I mean, you know, it's hard for me to say again, but I mean, that is a little bit more specific. I could tell you in New York, cases like that with like a dropped foot, with all those injuries, that I've seen many cases go for many millions of dollars, like 5 million and up in New York. Now, you know, I don't know what state this is in, or you know, every location is different. It also depends on all of the facts and circumstances of each specific case. Okay, let's see what other questions we have here. Here's a question from Oscar. He says, I slipped and fell at Walmart. I had surgery and finished all my medical. Now my lawyer is asking the defendant for $500,000. But if they don't offer that, he said he's going to ask for $600,000 and then a trial. If they don't take that, is it normal for a lawyer to ask for less and then go up on the offer? And you think my case is worth 500,000? Well, again, like I couldn't say if your case is worth, you know, because I don't know your case. I don't know what kind of surgery, what the injury is. So I couldn't really say if your case is worth that or not. But I mean, yeah, you could go up. I mean, usually the insurance companies don't like you to go up, but there is a certain technique where you could say, look, I'm giving you a settlement opportunity and you have 30 days, pay me the 500,000. If you don't, that's fine. But now then this is going to be off the table. The train has left the station and now we're just going to go to trial. And at trial, I'm going to ask for $1 million, right? Or more. So that's a technique I've used, and it's very successful. It's more of like a settlement opportunity where you flip the script on them, because essentially what the insurance company likes to do is say, look, we have, let's say, $1 million in reserves, and what's your demand? Oh, your demand is 500. Okay, let's give you 50. That's so high, 500. Why don't you come down to 300? Oh, you came down to 300. Okay, here's 75. Why don't you come down to 200? Oh, you came down to 250. Okay, we'll give you like 90. How about that? You know, and then they try to just like get rid of the case for as little as possible. They try to whittle you down. And then once you're at like say 250 or 200, you could never go back to 500, right? So it's like they're basically destroying your case, taking all your money away and preventing you from ever getting full justice. So I don't like to play that game. I just like to evaluate the case myself and say, look, this is worth X. Pay me X, or if you feel that my evaluation is too high, pay me something reasonable. You know, if you feel like 500 is too much, pay me 350 or pay me 300, or let's talk turkey. Let's go to a mediation, but give me a good faith offer to get me to go. I'm not going to go to a mediation and you're going to give me like 20,000, waste my time, right? And then if it doesn't settle, that's fine. You know, we'll just go to trial. Let a jury decide. Hey, sometimes they may win. You may lose a case. That happens too. Or you may win and it may be much more than the amount that we're talking about. A lot of times people are trying to settle cases for like 20,000 or 100,000. And when you go to trial, you're getting, you know, 5 times that number. You're getting like 600,000 or 700,000. So it just depends on each case, you know, what the case may be worth. And then someone asks, how much more does punitive damages usually add to a lawsuit if awarded? I mean, it's hard to say. Like punitive damages, it could add. There could be a wide variety. You know, it just depends on the case. Sometimes it can be very, very significant. If somebody commits like a real horrendous, horrific, you know, safety violation, disregard for public welfare, something that endangers the general population, the jury could get mad and say, look, pay punitive damages of millions of dollars. Sometimes they allow for punitive damages, but they're small, just a little bit of a punishment. So it just depends on the conduct, really. There's no real, you know, across the board. I mean, maybe there are statistics, but you'd have to look at every case all over the country, all the punitive. I don't really do that. That's more of like a statistician would do that, some kind of statistics. But from what I've seen, usually punitive cases are high money cases because if you can get punitive, it's hard to get punitives. It has to be punishment for egregious conduct, right? Really, really bad conduct. Almost like where they don't care about human lives, they don't care about safety, all they care about is profits. And they're saying, almost like clearly saying, hey, we care about our profits more than the safety of people, like profits over safety, profits over lives. If you could show that, then yeah, you can get punitives, but it's not that easy. Okay, let me see. Let me take maybe one more question before we wrap up, either from the comments or from the live. Let me see what we have here in the comments. I don't see anything else in the live, but if you guys have a question, feel free to drop a question. I'm going to see if there's a good question to answer in the comments, maybe. Let me see if I have any other questions that are good. Mm-hmm. Yeah, here's a question. I think this is a pretty good question here. Um, this is about 6 days ago. Someone says, I slipped and fell at a Target store and broke my back and got hurt on my knee. I already had my surgeries, and next month we will be sitting to negotiate. Not sure how much they will propose. I told my lawyer I would not settle for less than $2 million. After 1 year of my back surgery, I am having back pain and a lot of issues. Yeah, I mean, of course, that's a really serious injury. And if it's a good liability on the slip and fall, and it says, furthermore, it happened in Brooklyn. My deposition went well. I'm positive about my case. However, I saw my lawyer was not that serious in some cases, such as keeping documents in order and organized, where I had to struggle a bit. And now everything looks good, and hopefully I will get fair offer, so won't have to go for trial. Yeah, I mean, again, it's hard for me to say, but if you want a consult, just feel free to text me. I'm happy to do a consult and talk about the case and give you my input on it. But it sounds like a good case. I mean, it sounds like a serious case because if someone had a fracture, a broken back, and obviously Target should have enough insurance, so you have the possibility to get a large recovery. So I think that's good that you said, look, 2 million or more, because that's a life-changing injury. So absolutely, you should be compensated. Okay, thank you everyone for watching. Let us know what other questions you have. Next week, I will try to do a few topic videos. In fact, I may have to record a few videos about different topics because I may be going to trial soon and be unavailable for part of the summer. So I want to get some good content for you for while I'm away. But while I'm here, I'll try to keep doing the lives. If you have any other preference for the lives, like a certain time or a certain topic to cover, feel free to drop the comment on the channel or text me, email me, fill out the form, whatever you like. And please like and subscribe to our channel. And we are here for you. Okay, have a great day, everyone. Bye-bye.